Hi, it's Mike DelSignore, Massachusetts OUI lawyer. In today's video, I want to talk about the common question I get is, should you plead guilty to an OUI offense? So you're arrested over the weekend and you wonder, should you resolve the case? You feel like perhaps you drank too much. There might have been a crash. There's a breath test. And you have this feeling that you can't win the case. And you think of it because you feel you made a mistake. And what I want to tell you is, many of those cases can still be won. It could be that maybe a case is going to be a plea. You might be right. But in many cases, you're not right. So what you want to do is you want to focus on calling a lawyer, hiring a lawyer to review the case. Because when I look at a case, I'm not looking at it from the point of view of whether you made a mistake or whether you had too much to drink. And I'll teach you basically what it means to have proof beyond a reasonable doubt. I'll explain to you the legal process and how that's different from perhaps your own moral compass, or if you're calling for your child or for a spouse, what should have happened on that day or night. So, and that's two, so it's two different issues. And let's say you made a mistake and you have a problem with alcohol. I'll encourage you to get help, and you should get help, but I can still do my job and prevent you from having an OUI charge while you get help or rectify a problem that might have resulted from a mistake in judgment involving alcohol. So here's what I do. I'll get a copy of the report. I'll look at all the evidence, and I'll project how this is going to come out at trial. And I've done a lot of trials. I probably do about 2 trials a week, and I know how officers are likely to testify. So I'm looking for things that aren't necessarily contained in the report. So police officers are trained on the National Highway Traffic Safety Manual. So they have a manual. It's probably about 200 pages that documents everything you could possibly see and suspect if someone's under the influence of alcohol. So many of those clues aren't present in all cases. So what I look for is what's missing. What are the missing pieces? If you were intoxicated, the police should expect to see these things. Let's say there's 12 things. If they don't see all 12, then how significant are the missing pieces? And a lot of times I can make an issue of that, and I can show that the way you presented wasn't really consistent with somebody under the influence. Might have been, but might have been isn't good enough in court. It has to be beyond a reasonable doubt, highest degree of certainty. So we're not dealing with maybe, probably, we think so. The jury is told, and a judge has to, if it's a bench trial, they instruct themselves the same way. Even if you find a strong probability, it's not enough for beyond a reasonable doubt. So what we're looking for is we're looking for a plausible alternative theory. Could have been the driving could explain by you being tired. Could be that you drank socially. So we're looking for holes in the case. Sometimes that'll start with you didn't really admit to drinking too much. The odor wasn't strong. It might have been moderate. There was no crash. And then we take the field sobriety test, and I look for everything that you did right. And how the report's written and how the officer is going to testify can vary. Having cross-examined officers on field sobriety tests over the years, I've developed new methods and new ways to show that you've done very well on these tests. I realize that officers don't always have a real good grasp of actually what even happened. And so sometimes the report and what they testify can be two different things. So what I look for, a lot of reports are written that you may have missed heel to toe, you may have stepped offline. I point out that there's 18 steps when you take the 9 up, the 9 back. If the report says stepped offline, but it's not specific, suggests you probably were online the rest of the test. The missing heel to toe should be by more than a half an inch. Most of the reports don't say any distance. So how significant was this? So what I like to do is take everything they say on the field test, and I basically argue the judge that these are not major factors. They're minor things. You're on the side of the road, you're nervous, you've never done these tests, that it can be explained by somebody unfamiliar with the exercise. Whereas if we had you stumbling on some more major indicators, then we could say that could be alcohol. That's a stronger argument. But when we have minor indicators, it could be many things. So that's what I like to do, present the different possibilities, the range of ways we can explain this stop. So whether you should plead not guilty, generally you always want to plead not guilty at the arraignment. You don't have the video, you don't have all the reports, probably haven't had a chance to talk to an attorney. Make sure you hire somebody that has done a lot of these trials that can really explain how they realistically go in court before you resolve the case. Don't assume, for example, that a breath test is actually going to come into evidence. There are ways to keep that out. Think that just because you feel you made a mistake that you should resolve the case. I think that's the most common mistake people have. They just want to get it over with, almost because they feel bad they made a mistake, and it's almost sort of a self-punishment. And it's a noble way of thinking about it, and there's a lot to be said about a person that takes things that seriously, but it's different in court. So make sure you understand the difference between what a mistake and also a case being proven beyond a reasonable doubt. So it's a very high bar. In a lot of these cases, I can win. I've won a lot of these cases. Give me a call. I'll talk to you about the case. Call, text anytime, 781-686-5924. I look at police reports all the time for people. Give you my assessment before you even hire me. So feel free to reach out, and I'll answer your questions and help you make the best decision for your case.